All right, good afternoon, everyone. My name is Steve Jewett. I'm a county court judge from Orange County, Florida, Orlando. I'm a judge in the Ninth Judicial Circuit.
Good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
Good afternoon, Idaho, from your neighbor to the west. I'm Erin Lageson, and I'm the presiding judge of Department 3 of the Oregon Court of Appeals, and looking forward to hearing from you this afternoon.
And teams, you want to introduce the team? Want to introduce yourself?
Hi, I'm Emma Redmond. We're all juniors here at Meridian Medical, and I'm not sure if you want us to introduce our teacher, but
Sure.
It's Blake Goday.
And there he is.
I am Maddie Healy.
I'm Addie Barker.
And I'm Logan Drollet.
All right, great. Okay, folks, we're here in Unit 5, of course, and today's question is question 2. It reads as follows. This is a quote from Thomas Jefferson. He said, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? A couple of additional questions. First, what are the advantages and disadvantages of a national Bill of Rights as compared to a state Bill of Rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You have 4 minutes.
We agree with Thomas Jefferson because of John Locke's natural rights philosophies and popular sovereignty. John Locke believed that the purpose of a government was to protect the rights of the individual, once writing, quote, "The end of law is not to abolish or restrain it, but to preserve and enlarge freedom. For in all the states being capable of law, where there is no law, there is no freedom," end quote. Having a Bill of Rights gives the people power over themselves and their property, which is pivotal under a democracy. As well, the United States was created to inhabit the idea of freedom over tyranny, leading to popular sovereignty. The government gains its power from the people. We believe that this is the mindset that any creator of government systems should have.
A Bill of Rights ensures that each citizen will have some freedoms. Without a Bill of Rights, the government could have the grounds to interfere in citizens' lives in a way that is unwanted. Specifically, our negative rights protect our freedoms the most. When we look at places such as Russia and China, we see a population forced to conform, and that is not what we believe a nation should look like. In China especially, even though they have a Bill of Rights, citizens' rights to freedom of expression, and at the extreme end, the right to life and liberty, have been infringed upon. Roger Sherman once said, "Regard such privileges by the strongest expressions. Still, if you leave the legislative and executive power in the hands of those who are or may be disposed to deprive you of them, you are but slaves. People should carry the power of the government, not the other way around."
Advantages of a national Bill of Rights include every citizen in the United States being guaranteed their stated rights, or granted their stated rights. The United States has had a long, bloody history of states disagreeing on these fundamental rights, and a national Bill of Rights that directly applies to the states could have likely prevented some of the strife that this country has gone through. The downside of this is that these rights that exist at a federal level must be incorporated into the states through long, drawn-out Supreme Court cases such as Mapp v. Ohio. Having a Bill of Rights at the state level also could better represent the needs of the residents of a particular state as compared to broader national rights. Wherever these rights become broad, there is room for interpretation and government overreach into these rights. National rights can be ignored, however. In the case of the 13th, 14th, and 15th Amendments, states still went out of their way to try to deny citizenship and suffrage to Black American citizens in post-Civil War America. This unconstitutional discrimination occurred for a century after the Civil War, and still occurs to some degree today, and required the intervention of the Army in instances like the Little Rock Five to intervene and ensure that these rights were being provided to every citizen.
In the preservation of liberty and limiting the government, our negative rights are the most important. Positive rights place a positive duty on others and include rights like schooling, healthcare, and minimum wage. Negative rights are rights that you have that no one may interfere with, mainly the government. Some negative rights include your freedom to speech, freedom of religion, and the right to bear arms. Even the positive rights found in the 5th through 7th Amendments are in support of negative rights, including habeas corpus. In the case of Lemon v. Kurtzman, in an 8-1 decision ruled that the government funding to non-public religious primary and secondary schools violates the Establishment Clause under the First Amendment. Negative rights are held in a higher regard. As we see in the case cases like Lemon, the court ruled out exactly what the government can and cannot do. A major right you have is habeas corpus and the rights associated with a fair trial. The Sixth Amendment guarantees your right to a public, undelayed trial, the right to a lawyer, the right to an impartial jury, and the right to know the claims being made and who their accusers are. Under the writ of habeas corpus, if you are imprisoned or detained, you have the right to a trial to ensure your imprisonment was valid. Looking at how habeas corpus has evolved, two main theories become present: the judicial power theory and conflicting ideologies theory, both of which have been explored in the writ's history, in cases including Gideon v. Wainwright and Brown v. Allen. Without the writ of habeas corpus in the Sixth Amendment, the government could do as they please after your detainment. Therefore, our negative rights are the most important when looking at the preservation of our liberty.
All right, thank you. What limits, if any, should be placed on the rights that are in the Bill of Rights? And how should those limits be placed?
Well, with freedom of speech, we already see that that like threats towards others are not protected whatsoever. Like assault, which is an actual crime. Addie.
I'd also like to speak on the freedom of religion in the First Amendment. We've seen in cases such as Prince v. Massachusetts that when it comes to a point where it's affecting the life of a child, in Prince v. Massachusetts, they talk about how you cannot, or a state can enforce a compulsory vaccine law, regardless of like religious exemptions, because it affects how, or you don't have the right to take your religion so far as to affect your child's life or expose them to a communicable disease that could potentially take away their life. So.
Okay.
As you've acknowledged, the contours of the rights in the Bill of Rights are frequently developed through court decisions. If somebody was wanting to extend a right in some way or add new content to it, do you think it makes most sense to do it under a state constitution, through state courts, or under the federal constitution and federal courts? Why?
I think that it could be easier to do it, well, not easier, it could prevent problems if you do it at a federal level. Because if you're talking about adding things to different state constitutions, if you have something between one state and another that is a disagreement, that is, you have to go through different courts and you have one ruling, they change the amendment that, you know, makes something illegal in one state but not in another, it could cause problems that would eventually need the federal constitution to kind of even out those issues. So I think that starting at a federal level could prevent those issues. But if you look at a state level, that could be easier to try to get rights elaborated on, or however you want to edit them. And it just become a quicker process.
What circumstances, if any, would cause a person to lose rights found in the Bill of Rights?
When we see people, for example, people that have been arrested, we can see that they might lose rights, maybe not even, you know, specific rights in the Bill of Rights, like the right to vote, but we also see different groups of people have different groups of rights. So children have, you know, different rights in different places, like schools have different rights. For example, like the Fourth Amendment, sorry, about search and seizure, schools have a lot more room to search students' possessions than like the overall government would have. So it depends on kind of like groups of different people and different organizations can have different ways that they do the rights.
I agree with my colleague over here. She mentioned that certain people will have those rights taken away, mentioning criminals. So a lot of times when they are released from these prisons, they won't be allowed to obtain a firearm, or they will have to jump through many more hoops in order to secure a weapon. And so that is an instance where that might be taken away from a person.
Okay. Supreme Court Justice Antonin Scalia was known as an originalist, and his belief as the Supreme Court Justice was, if it's not in there, you know, if it's not written out, and we go with the text, what do the words say? which is sort of a rigid way to look at the Bill of Rights. Do you agree with that position, that it should be read rigid, you know, direct to the text, or do you think that it's more fluid than that and should be more fluid than that? And apply that to one of the amendments, for example, the Second Amendment, probably the easiest one to apply to.
Yeah, I definitely think that it should be more fluid rather than just rigidly based on what the text says. I mean, you mentioned a great example of the Second Amendment. When the Second Amendment was made, they were using muskets, which are very different from the type of guns that we have available to us now. I mean, AR-15s are very, very different from muskets, like I said. So I think that when you look at how our society and our government has evolved, it would be almost illogical to read strictly off of the text, because then you ignore, like I said, the evolution of how we've changed and how our, you know, parties have changed, how our ideologies have changed.
And going along with that, well, with the Second Amendment, when you also look at our current military now versus the military of when the Constitution was written, those are two very different things. So that has been something that has changed drastically. And when the framers were writing the Constitution, they wrote it in a way that could be interpreted differently as the country went along. They didn't want to write a set in stone document that was just for the time that they were in. They wanted a document that would last through time. So looking at it exactly how it was written over 200 years ago doesn't make as much sense when you can look at how our world is today, very different world, and try to reinterpret it in a way that would make more sense now.
To follow up on the last question, one of the rationale for Justice Scalia's philosophy is that when rights are expanded through judicial interpretation by unelected lifetime tenure judges, we're circumventing the process for amending the Constitution, the political processes. What would be your responsive argument? Why is interpretation not, in fact, amendment to the Constitution?
Well, I mean, judicial review is something our country has had since 1803, and I feel like no one will say, well, there are people who will say like judicial review shouldn't exist, but that they're a vast minority. And judicial review's entire point is to make sure that we like determine the purpose of the Constitution, and that changes throughout time. And there are so many things that have been like ruled upon with judicial review that never existed at the time that the Constitution was written. And the process through which we get an amendment through Congress can be very lengthy, and sometimes we need these decisions to be made fairly quickly.
Are there any positive rights that you think should be added to the Bill of Rights?
I think something that we could add for a positive right, because we, you know, with the courts, we have, you know, the right to a jury and a lawyer and everything, but maybe even adding more for that, making sure that people have lawyers that they get along with. We can add multiple lawyers, something like that, to give them better representation in court.
All righty, thank you. Good job. You guys want to jump in?
Well done, guys. Your prepared remarks, you answered the question. You took a position and made it clear that you agreed with Thomas Jefferson. And you went through and you explained natural rights. I liked your references, historical references to John Locke, and you identified the advantages with regards to having a national Bill of Rights, and some of the advantages with regards to state rights or state constitutions and state Bill of Rights, and how the two are complementary and work together. You also identified some pros or some cons with regards to amendments being set forth through State Bill of Rights. I thought that you did well in identifying specific examples with regards to the positives with positive rights and negative rights. And in specific instances, when you mentioned the 13th, 14th, and 15th Amendment being needed, in cases like the Little Rock Five, you referenced a number of specific events as evidence in support of your positions. I thought that was well done. And it was clear that you guys put some time in, and you had a good grasp for the most part with regards to natural rights, negative rights, and National Bill of Rights versus state constitution. So good job.
I would echo those comments. I enjoyed listening to your presentation, and I especially enjoyed listening to your discussions of the role the state constitutions can play in the discussion of the relationship between the state constitution and the national constitution. And I thought Steve and I gave you some challenging questions on interpretation, but they are ones that are pretty much at the forefront of the constitutional law discussion. I thought the answers are good, particularly I think, Logan, you came in with the role of judicial review and how it has been around for a while. And that has been one of the ways that we, I mean, the nomenclature is important. Some people would say you are amending the Constitution without going through the process. Others would say you have to decide these cases, and that's the court's job under judicial review. And I thought that was a very good insight by you. So, nice job, group.
Good job, you guys. It was all there. Your prepared statement was great and answered the question and went through it. I don't really have anything else to add other than what everyone already said. I do like the interplay between the federal and the state constitution and the Bill of Rights. That's sort of my thing. And you guys, you hit on that and were able to answer those questions appropriately. So I appreciate that. Good job, you guys.
Yeah, good job.
Good job.
Good luck.